Lesson: Drafting effective employment agreements, best practices. Drafting effective employment agreements is a critical skill for HR leaders, especially those aspiring to excel in international employment law. Employment agreements serve as the foundation of the employer-employee relationship, defining roles, responsibilities, and expectations. They protect both parties' interests and provide legal recourse in the event of disputes. Therefore, understanding how to draft comprehensive and enforceable agreements is essential. To begin crafting effective employment agreements, HR leaders must first understand the legal framework governing employment contracts in their jurisdiction. Employment laws vary significantly across countries and even within regions, which can impact the enforceability of certain contract provisions. For instance, non-compete clauses may be enforceable in one jurisdiction but void in another due to public policy considerations. A comprehensive understanding of local employment laws, therefore, is the first actionable step in drafting an effective agreement. Once the legal framework is understood, HR professionals must focus on the key components of an employment agreement. These typically include the job title, description, and duties, compensation and benefits, confidentiality agreements, and terms related to termination and dispute resolution. Each section of the contract must be crafted with precision to avoid ambiguities that could lead to disputes. For example, a job description should be detailed enough to convey the core responsibilities, but flexible enough to allow for changes as the role evolves. This balance can be achieved by using words like including but not limited to when listing duties. In terms of compensation and benefits, clarity is paramount. The agreement should specify the salary, payment frequency, bonuses, and any other financial incentives in clear terms. Additionally, benefits such as health insurance, retirement plans, and paid leave should be outlined. In a global context, HR leaders must also consider the implications of expatriate assignments, where compensation packages may include housing allowances and relocation assistance. A practical tool in this area is a compensation matrix, which can help in visualizing and ensuring equity in pay across different roles and locations. Confidentiality is another essential component of employment agreements, especially in industries where sensitive information is handled. A well-drafted confidentiality clause protects proprietary information and trade secrets even after the employment relationship ends. It's crucial to define what constitutes confidential information and to outline the obligations of the employee in maintaining confidentiality. Case studies have shown that clear confidentiality agreements can deter potential breaches and provide strong grounds for legal action if breaches occur. Termination clauses are equally critical as they can prevent costly legal disputes. These clauses should detail the circumstances under which the employer or employee can terminate the agreement, the notice period required, and any severance pay entitlements. HR leaders should consider including a dispute resolution mechanism, such as arbitration, to resolve conflicts without resorting to litigation. A step-by-step approach to drafting termination clauses involves identifying potential termination scenarios, determining fair notice periods, and consulting with legal counsel to ensure compliance with local labor laws. In the realm of international employment agreements, cultural considerations play a significant role. HR leaders must navigate cultural nuances and expectations when drafting agreements for a diverse workforce. This may involve adapting the language and tone of the agreement to suit different cultural contexts while ensuring that the core legal principles remain intact. A practical framework for addressing cultural considerations is Hofstede's cultural dimensions theory, which can guide HR professionals in understanding and adapting to cultural differences in the workplace. Using real-world examples, the importance of these practices becomes evident. For instance, a multinational corporation faced legal challenges when its standardized employment agreements did not comply with the labor laws of a new market it entered. By revising its agreements to align with local regulations and cultural expectations, the company was able to mitigate potential legal risks and improve employee satisfaction. Another case study illustrates the effectiveness of clear termination clauses. A tech company faced a wrongful dismissal lawsuit which was settled swiftly due to the robust termination provisions in its employment agreements. The contracts clearly outlined the grounds for termination and the steps involved, which the company adhered to scrupulously. This example underscores the importance of having detailed and legally sound termination clauses in employment agreements. Statistics further highlight the significance of well-drafted employment agreements. According to a survey by the Society for Human Resource Management, companies with comprehensive employment agreements experience 30% fewer legal disputes related to employment contracts compared to those with less detailed agreements. This statistic underscores the value of investing time and resources into the drafting process. In addition to the aforementioned components, HR leaders should consider including clauses related to intellectual property, especially in industries where innovation and creativity are key. These clauses ensure that any inventions or creations developed during employment are owned by the company. A clear intellectual property clause can prevent costly disputes over ownership rights and encourage innovation within the company. HR leaders can enhance their proficiency in drafting employment agreements by regularly updating their knowledge of employment law and best practices. Attending workshops, engaging with legal counsel, and participating in professional networks can provide valuable insights and keep HR professionals abreast of evolving legal landscapes. Additionally, leveraging technology, such as contract management software, can streamline the drafting process and ensure consistency across agreements. In conclusion, drafting effective employment agreements requires a comprehensive understanding of legal frameworks, precise language, and consideration of cultural nuances. By focusing on key components such as job descriptions, compensation, confidentiality, and termination clauses, HR leaders can create agreements that protect both the employer and the employee. Utilizing practical tools and frameworks, such as compensation matrices and Hofstede's cultural dimensions theory, can further enhance the drafting process. Real-world examples and statistics demonstrate the effectiveness of these strategies, underscoring the importance of well-crafted employment agreements in minimizing legal risks and fostering positive employer-employee relationships.